This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only. Hey, Jamie Carper here. Today's case is about free speech, public employment, and the exact moment your First Amendment rights clock out for the day. The case is Garcetti v. Ceballos, 547 U.S. 4102006. Here's the setup. Richard Ceballos was a deputy district attorney in Los Angeles County. His job included reviewing cases and making recommendations to supervisors. While doing that job, he came across what he believed were serious inaccuracies in a sheriff's affidavit used to obtain a search warrant. So Ceballos did what prosecutors are literally paid to do. He wrote a memo to his supervisors recommending dismissal of the case. The office disagreed. The prosecution went forward anyway. And after that memo, Ceballos says his work life took a turn. He was reassigned, passed over for promotion, and generally placed in what we in law call the professional doghouse. Ceballos sued, claiming retaliation in violation of the First Amendment. Now let's walk through the lower courts. The federal district court ruled against Ceballos, holding that his memo was written as part of his official job duties and therefore not protected speech. The Ninth Circuit reversed, saying the memo addressed a matter of public concern, government misconduct, and that should trigger First Amendment protection. So the Supreme Court steps in to answer the real question here. When a public employee speaks pursuant to their official job duties, are they speaking as a citizen or as the government itself? And if they're speaking as an employee, does the First Amendment protect them from discipline? That's the issue before the court. Let's go inside.
We'll hear argument this morning in Garcetti v. Ceballos.
Mr. Chief Justice, and may it please the court. When public employees speak pursuant to their official duties, they are not speaking as citizens for First Amendment purposes. Their speech is part of government operations and subject to employer control.
So your position is that the First Amendment simply doesn't apply when the speech is required by the job?
Correct, Justice Scalia. Otherwise, routine employee communications become constitutional events.
But what if the speech exposes government misconduct?
The remedy is internal discipline, whistleblower statutes, or political accountability, not constitutional litigation.
If we extend First Amendment protection here, how does a government employer manage its workforce?
It becomes nearly impossible, Justice Kennedy. Every memo could trigger a lawsuit.
Counsel for respondent.
Mr. Chief Justice, and may it please the court. Mr. Ceballos spoke on a matter of public concern, false statements in a search warrant affidavit. That speech deserves First Amendment protection.
But the memo was written as part of his job responsibilities, correct?
Yes, but the Constitution should not disappear simply because the speaker is doing his job.
If the employee's speech owes its existence entirely to professional responsibilities, how is the employee speaking as a citizen?
Because public concern should be the controlling factor, not the job description.
That sounds like a rule that turns every workplace disagreement into constitutional law.
Only where the speech exposes wrongdoing.
Thank you, counsel.
The First Amendment protects citizens, not government employees, acting as employees. When speech is made pursuant to official duties, the government employer must retain control over its own operations.
But this rule risks silencing those best positioned to expose wrongdoing.
That concern is real, but the Constitution is not the only safeguard. Legislatures can enact whistleblower protections. If we constitutionalize employee speech made on the job, courts become super personnel departments.
Still, prosecutors have ethical obligations. Suppressing speech about false affidavits is troubling.
But the line must be administrable. Speech that exists because of the job is not citizen speech.
This creates a categorical rule, one that leaves valuable speech unprotected.
It does, but without it, government cannot function effectively. So the rule is simple. Speak as an employee, no First Amendment claim. Speak as a citizen, maybe.
Justice Kennedy has the opinion of the court.
We hold that when public employees make statements pursuant to their official duties, they are not speaking as citizens for First Amendment purposes. The Constitution does not insulate their communications from employer discipline. Because Ceballos wrote his memo as part of his job, his speech is not protected under the First Amendment.
I respectfully dissent. The court today strips First Amendment protection from speech that matters most truthful speech by public employees exposing government misconduct. Richard Ceballos spoke as a prosecutor fulfilling his professional duty, raising serious concerns about false statements in a warrant affidavit. The majority's rule draws the wrong line. By holding that speech made pursuant to official duties is unprotected, the court discourages integrity and transparency within government and creates a chilling effect on responsible internal reporting.
I join this dissent. Public employees do not forfeit their constitutional rights by doing their jobs. The First Amendment should protect, not punish, speech that seeks to correct official wrongdoing.
Whistleblower statutes are no substitute for constitutional protection. Today's decision weakens the First Amendment and shields misconduct from scrutiny. I respectfully dissent.
All right, here's the holding, straight up. When a public employee speaks pursuant to their official job duties, they are not speaking as a citizen, and the First Amendment does not protect that speech from employer discipline. Why does this case matter? Because it draws a hard line in public employee speech law. Before Garcetti, the key question was what you were talking about matters of public concern. After Garcetti, there's a new threshold question. Who are you speaking as a citizen or an employee doing their job? If it's the job talking, the First Amendment steps aside. That has huge consequences for teachers, prosecutors, police officers, and government professionals who speak up through official channels. The court says constitutional protection isn't the answer statutory whistleblower laws are. Whether that's enough protection is a debate that did not end in 2006. I'm Jamie Carper, and remember, free speech is powerful, but at work, who you are speaking as matters just as much as what you say.